The stay of proceedings application was aimed at getting the court to halt the trial pending the final determination of an appeal on the decision of the court to hear the matter on day-to-day basis. At the Court of Appeal on Wednesday, Gyakye Quayson argued that proceedings at the court below have been tainted by events that affect the fair trial of the case. Gyakye Quayson noted that the decision of the High Court to dismiss an application for further disclosures by the state amounted to a breach of his client's right to fair trial. He contended further that some alleged prejudicial comments made by the President, Attorney General, and some ministers shows a predetermined agenda to see his client in jail. But Attorney General Godfred Yewardam, in opposing the application, referred to it as unmeritorious. In his view, the alleged prejudicial comments did not have any effect on the decision of the High Court, as those attributed to the President and other ministers were made after the decision of the court. He rather accused Gyakye Quayson of using the application as a ploy to avoid trial. According to him, the allegations of a predetermined agenda to jail the accused by his lawyers point to a strategy to avoid trial. As per those allegations, the NDC legislator seeks to avoid trial. He urged the court to dismiss the application, as no exceptional circumstances have been proved to warrant a stay of proceedings. The three-member panel, after considering the application, dismissed it. According to the court, no exceptional circumstances were raised to warrant a stay of proceedings, and the alleged prejudicial comments are extrajudicial, which did not have any impact on the decision of the trial judge. The judges also ruled that the decision to hold the trial on day-to-day basis does not in any way affect Gyakye Quayson's right to fair trial. NDC's head of legal affairs, Abraham Amaleba, who spoke to the media, expressed the disappointment of the legal team.
We are still soldiering on. Even though this has been dismissed, we still have some applications at the Supreme Court and we'll pursue it. But it doesn't come to us as a surprise. How, in God's name, can the statements made by the President not weigh on a judge who is appointed by that same President? How, in God's name, can comments from the judge, the President, not have an effect on a judge who was appointed by the President? So I'm saying that I'm not surprised.
Meanwhile, the cross-examination of the first witness of the state in the perjury trial against James Gyakye Quayson continued. His lead counsel, Gyakye Quayson, questioned the witness whose complaint to the police resulted in the instant trial. On his statements to the police, Mr. Quayson inquired about some documents that the witness claimed to have attached to the police statement but was not disclosed to them by a prosecution. The witness, however, explained that he attached the documents to the petition submitted to the police even though he stated on his police statement that the documents were attached. The Attorney General clarified that the documents were attached to the petition and not to the police statement. Gyakye Quayson therefore made an application for the Attorney General to make further disclosures of the said documents attached, or the police be made to issue a certification on whether the documents were attached to the police statement. The application was, however, dismissed. The case has been adjourned to July 26, 2023. Abraham Amaleba spoke to the media after proceedings at the High Court.
We have filed for an interpretation. That's an interpretative issue at the Supreme Court on Article 19 of the Constitution, which has to do with fair trial. And you know, all this brouhaha is about whether the accused person would have fair trial. And so we want the Supreme Court to interpret Article 19. What does fair trial mean? Does it mean the accused person must be coming to court every day? Is that what fair trial means?